The Attorney-Client Relationship Part 2, the Case Law. Lawyers, Lawyering, and Litigation, Dr. Peter Baxter, Law and Jurisprudence Program, Spring Semester 2015. Well, let's continue with what we built upon, or hopefully you have built upon, from the last audio lecture, and look at the case law concerning the attorney-client relationship. First case I want to review with you is in re matter of, or in re Fordham, or in the matter of Fordham, a case coming out of Massachusetts. So what was going on in this case? Well, you have a basic DUI case, driving under the influence. And the question before the court was whether the attorney in taking the case had really bit off more than he or she can chew. We have an experienced attorney who has never had a DUI case before and now has one. So the question is, the attorney turns around and decides to charge $50,000 for a DUI case and claimed a total of 227 hours to work on it to get familiar with the case. What the client does is turn around and claims that this is clearly excessive. Okay? So the attorney is taken before the Massachusetts Board of Overseers, a part of the Commonwealth of Massachusetts Bar Association. The Board of Overseers said no. The bar counsel, the person appearing as the prosecutor, if you will, before the Board of Overseers, decides to appeal the Board of Overseers' decision. It goes up to the court, and the court in Massachusetts says yes, that the charges are clearly excessive. Okay? And in kind of a spiteful little decision, the court says the following. First and foremost, the court argues that one shouldn't have to pay for the attorney's education. $50,000 for a DUI, in a sense, so that the attorney can educate themselves on what a DUI involves. It's clearly the client paying for the attorney's education. Secondly, the court said the attorney never gave a proper estimate as to how much it would cost the client. The client, to be fully informed, should be informed as to the fee that will be charged. Third, the learning time is permitted. Learning time is permitted, and the client will have to pay at times for the attorney to get up to speed on a case. But they said that learning time in excess of $50,000 is excessive. The typical DUI with learning time comes to about 30 hours, not 227 hours. So the court, in this spiteful decision, basically says that yes, the client does have to pay for learning time, but not 227 hours of it. The advice here that we should reflect upon is you really got to question whether the attorney should not take cases in which he is not qualified. If an attorney takes a case, they really should vie away from cases in which they're not qualified. The learning time alone, the catch-up, and the chance of mistake is so much greater if you take an area of law with which you're not familiar. So an attorney, even taking a simple DUI case, I guess it's not that simple. The second case I want to look at is the Committee on Professional Ethics and the Conduct of the Iowa State Bar Association versus Mershon. In this case, we had a discussion between three individuals, a farmer, an engineer, and a lawyer. And they agree, the farmer wants to develop some of his land. And they form a corporation, a 3-person corporation. And the engineer and the lawyer decide that instead of charging the farmer a fee, they would take stock in said corporation, in the development. So everything sounded good at the onset. They accepted stocks in lieu of payment, and they made a three-person land deal. Well, what happens is the deal fell through just after the farmer dies. So now we have three parties in dispute with each other as to who owes what to whom. Well, we don't really care about engineering malpractice. What we do care about, though, is legal malpractice. The Board of Discipline, then, in hearing about the case, questioned whether this put the attorney in jeopardy. In other words, in a position where he or she is representing, in a sense, clients' differing interests. In other words, representing one client over another or themselves over one of their clients. So we call this differing interests. Now, in New York and many other jurisdictions, we call it the hot potato. So this idea of representing oneself and one's client in opposing counsel, in a sense, is the hot potato. This comes from New York State Bar Association Lawyers Code of Responsibility, DR 5105. And we have similar codes of ethics, which basically talk about the rise of a hot potato issue and ways in which to stay away from it. So, what happens? Well, the Board of Discipline questions the attorney, and the case is brought before the court. The court holding is yes. What we do have here is an attorney representing differing interests. The attorney should be reprimanded, since initially, when he talked about this scenario, he didn't fully disclose his role in it. And if he was to come to represent different interests in a land deal, especially if the land deal didn't go through, he had an obligation to his client, who was initially the farmer and the engineer. So it sounds like a joke somewhere there. A farmer, an engineer, and a lawyer go into a corporation. Anyway, so what we have here is a hot potato, a differing interest scenario, and the attorney should be reprimanded. What can we draw from this case? Be very wary of getting into business with your clients. And if you do so, full disclosure at the onset and at every stage of the relationship. Now, from the last audio lecture, we talked about the idea that sometimes the attorneys will take this form of payment, a stock interest or something, in lieu of a regular court attorney's fee. But be very wary, especially in an initial business that might have the chances of failing, which all businesses do, in that you might come to represent your interest against the interest of the corporation to which you're a member, or the members of the corporation besides yourself. You might duke it out in a sense. So be very wary of entering or getting into business with your clients. And if you do so, full disclosure at every stage of the process. The third case I want to look at is the case of Jones versus Barnes, a case that questioned the Sixth Amendment of the U.S. Constitution. Now, the Sixth Amendment is kind of like the 14th. It has a lot in there, speedy trial and the like. The part I want to focus on is effective counsel. Okay, the concept of effective counsel. Factually, what's going on here? Well, we have an indigent client who comes to court and is assigned. Part of our pro bono duties as attorneys is that courts at times will assign you cases where you won't get paid. It's part of our Bar Association's concept of duty to one's community. So, look out, hanging out in court too long. A court judge might all of a sudden, railroad you into a case pro bono, in which you won't get paid. In this case, we have an indigent client in an robbery and assault case. And those were the actual charges brought against the client. The attorney was given the case of this client, and while the case was going on, the early stages of the case, the client decided to bring up a whole bunch of other claims. The client told Mellinger, that's the attorney. David Barnes is actually the convicted robber. Well, the accused robber and assault person. A bunch of claims were brought up. Some of these were not in evidence on the record. Several other claims that were brought forward by the accused were not supported by any shred of evidence or any logic to it. And what happened was Mellinger, the attorney, decided not to pursue those claims. So the issue before the court becomes, does the Sixth Amendment force the attorney to represent every claim that his or her client wants brought forward? Okay? And if he or she doesn't do it, is he or she in violation of the Sixth Amendment? Ineffective counsel, ineffective assistance of counsel. Well, the Second Circuit heard this case, and they said that nothing in the Sixth Amendment compels an attorney to raise every claim, especially claims that are not supported by the evidence. It would be a waste of court time. It would be a violation of their oath. It would be a violation of even the Sixth Amendment. So he was contracted by the judge to represent Barnes, the accused, on robbery and assault, not on other various claims that the indigent client wants to bring against the state. So the charge of ineffective assistance of counsel in violation of the Sixth Amendment was lifted. Decision then was heard by the U.S. Supreme Court, since, a key part of our Constitution was being questioned here, and they upheld the decision of the Second Circuit. Okay. The final case I want to look at is the case of Tugs versus Vesely, Otto, Miller, and Keef. And if you can't tell that the latter party isn't a law firm, then I don't know what's wrong with you. What's going on here? Well, basically what we have here is a potential question of medical malpractice bleeding into a question of legal malpractice. Factually, an attorney was consulted by a wife whose husband was exposed to a serious accident in the hospital while undergoing treatment. So the question here would be one of medical malpractice. The attorney, in listening to the husband's plight in the hospital, was asked by the wife, do we have a case here? Do we have a case? And the attorney said that he would consult his colleague in the law firm and get back to her. The problem is the attorney never did, never consulted her again. That was the end of their relationship. What happened was, by not contacting her, she understood it to mean that she had no case. So she didn't pursue a case initially. She waited, and it bothered her because she thought she had a case of medical malpractice. So after a year, she approached a second attorney, about 1 year later, and she found out that she had, in fact, a case against the hospital, a $650,000 case. The problem is, in the time that it took, the statute of limitations on medical malpractice, which is 2.5 years total, had run out. So even though she might have had a case, it was possible, and a large sum case, $650,000, the statute of limitations, SOL, had run out. Thus, she didn't have a case because the statute had run. You cannot bring a legal action if the statute of limitation in which you have to sue has run out. So, instead of medical malpractice, she turns back to the attorney and charges him with legal malpractice. So there were basically two questions before the court. Had an attorney-client relationship been formed in that consultation between the initial attorney and the wife of the husband? Had an attorney-client relationship been formed? And secondly, had the attorney in the first case caused legal malpractice? The answer to both was yes, that an attorney-client relationship had been formed, even in this initial consultation. And secondly, that attorney had caused legal malpractice. The court said a relationship had been created immediately on consulting with the client. And just because the attorney forgot to either consult with his colleague or get back to her once the consultation was complete wasn't the client's fault. It was the attorney's fault. An ongoing relationship had been created. Secondly, legal malpractice had also occurred because the attorney failed his or her duty to the client. And this failure was the actual or legal proximate cause of damage to the plaintiff, a loss of a possible $650,000. And that's how legal malpractice works. If you fail a duty as a professional, and legal malpractice, the profession is law, so attorneys and lawyers, if you fail a duty of care, and that duty of care in negligence is illegal, proximate, meaning intervening variable, or direct cause of damage to the plaintiff, the client, the woman, the wife, then you are responsible for legal malpractice. And we have a loss then of $650,000 to the wife, the husband, the estate, the family of the initial client. Well, you know what that means. That means our lecture series on the attorney-client privilege is over. The cases have been reviewed, and I hope you found this audio lecture useful. Obviously, you like you would do with shampoo, rinse and repeat. If you didn't understand something, go back to it. Shoot me a question if you have it. And slowly this cold is no longer dominating my life as we know it. I hope to see you all very, very soon.